Hello there. My name's Michelle Everson, Professor of Law at Birkbeck College, University of London, and I've been asked to give you a quick resume of the vice judgment of the German Constitutional Court. The judgment was given on the 5th of May, so only a couple of weeks ago, and has now unleashed a massive commentary, some of it hugely angry, assuming that the German Constitutional Court has raised itself above the European Court and is seeking to undermine the whole construct of European Union. So, looking at this rather exciting judgment, I've been asked to deal with three questions. First question, what does the judgment actually say about the European Central Bank and its quantitative easing programme? Also, what does it say about the claim to primacy or supremacy of the European Court of Justice over European law? Second question, though, was this an expected judgment? Quite interesting. I'd say yes or no, yes and no, but we'll come back to that in a bit. And then third question, where do we go from here? So, dealing with the first question, what does the German Constitutional Court say? I always have to look this up, about the central bank's public sector purchase programme, its quantitative easing programme, which was set up in 2014, I think, to pump money into the economy, ultimately to raise the inflation level. Remember, the European Central Bank is given, under the European Monetary Union construct, powers over monetary policy. It's not given powers over economic policy. That remains very much a matter for the member states. Now, quantitative easing, certainly according to the German Constitutional Court, is not simple monetary policy. This has an obvious impact on interests in the real economy. There are people who will prefer higher interest rates, pensioners, what have you, to maintain the value of savings, against people who want lesser rates to enable liquidity, to enable borrowing within markets. So quantitative easing, ultimately printing money, what have you, is the German Constitutional Court does not say that it's ultra vires, that the central bank is acting outside its powers in engaging in this. It says, okay, you can look at this, that it's as if it's an element of monetary policy, but you must also admit that it's going to have certain consequences in the economic policy sphere. And before you go ahead with that, you must undertake a proportionality requirement, a proportionality test. You must check that this is an appropriate thing to do. Ultimately, though, I think best to think of this proportionality test that the German Constitutional Court is talking about in terms of it being a statement of reasons. They want the court to show its workings. They want the bank to show its workings. They want them to say, yes, this could impact badly on pensioners, but in terms of lending in an immediate requirement, it's a necessary adjunct, or it's a necessary side effect of this monetary issue. So it's the lack of that statement of reasons, the proportionality test, that leads the German Constitutional Court to say that the European Central Bank is acting outside the powers afforded to it by the treaties. At the same time, of course, in coming to this decision, on the central bank, the German Constitutional Court does appear to be usurping the role of the European Court of Justice, because it's really for the European Court of Justice, you would think, to decide about the appropriateness or otherwise of European Central Bank action. So, and this is the really exciting part of the judgment, in taking upon itself the right to test the correctness of central bank actions, the court is concomitantly, and saying it explicitly, claiming that the European Court of Justice, in giving its go-ahead to the programme, was acting outside its powers had failed to set the limits to the technocratic action within the treaties, had failed in its competence review. Now, this aspect is a really tricky part of the judgment, and I think we immediately link into the second question of was this expected or not? At a certain level, absolutely expected that the German Constitutional Court would eventually say to the European Court of Justice, enough, you are expanding the scope of European law beyond that is desired by the member states by not fulfilling your functions of limiting the actions of European institutions, and especially the technocratic actions of technocratic institutions like the European Central Bank. Really is it's an inevitable feature of the German Constitutional Court's historic view that European law still, despite its self-description as a supreme legal system, still does not have its own competence or right to designate the breadth of its own competences. That right remains with the masters of the treaties, which are the member states. So the member states remain sovereign. European law is not sovereign. European law is supreme only within the competences afforded to it by the member states. And this judgment that the European Court of Justice had failed to prevent the European Central Bank from moving from monetary policy, approved of within the treaties, into general economic policy is an inevitability of that line of reasoning. That was always going to happen from the Brunner judgment 1994 onwards through OMT, Lisbon, what have you. This has been the position held by the German Constitutional Court. The surprise, of course, where is this judgment perhaps unexpected, comes that the court has pronounced in relation to monetary policy, in relation to the euro, and pronounced at a time of yet more crisis for the euro, and exactly at the time where the bank is again purchasing, but to prevent troubles during the corona crisis. There is the new pandemic emergency purchase programme, more quantitative easing, more support from the bank, such that the fear would be that the German Constitutional Court, in doubting the legitimacy of such schemes, is also creating yet another danger that the Eurozone will collapse. So this was a surprise. The court that barks has suddenly appeared to have bitten. Or is this really the case? Now, seriously, no. The court has left plenty of wriggle room, both in relation to the public sector programme and in relation to PEP. Firstly, in terms of the schemes that are addressing the coronavirus, the court was very clear that this judgment does not apply to them. A completely new process would need to be started, and if challenges were to be made about those programmes, and clearly those challenges go on for years, the process is long. But also in relation to the demand that has been made of the European Central Bank, that it now makes a statement of its reasoning in relation to the public sector purchasing programme. This is not a high bar. It's not a high bar. The court has not lay down a substantive value here at all. As I say, it's a statement. It's a rule of reason. It's the court that the bank should be able to produce a report that satisfies the demands laid down by the German Constitutional Court. Equally, should the bank fail to do so, the results, it's limited only to the participation of the German central bank within the scheme. The German Constitutional Court only claims, quite correctly in legal theory terms, authority over the German legal system. So it would only have an impact to the degree that in 3 months' time, there's the time limit set, the German central bank could no longer play its part within the programme. So overall, there's plenty of time, there's plenty of wriggle room. There are ways of avoiding the appalling economic consequences of a collapse in belief in the Eurozone that might follow this judgment. So what comes next? Probably a period of negotiation. As stated, what comes next? Probably a period of negotiation. There's the immediate negotiation to shore up the European Central Bank programme. Now, these sort of negotiations are a matter of institutional, Eitelkeit, we would say in German. It's going to be difficult. The Commission has already indicated that it feels that the German Constitutional Court has overstepped the mark in seeming to undermine the position of the European Court of Justice and its supremacy. The European Central Bank is also clearly a little bit annoyed, but ultimately I think cool heads will prevail, and some form of words, some form of report will be found that will allow for a smoothing over of the institutional aggro. I do not see an action being brought against the German Constitutional Court by the Commission for a lack of respect for European law, quite simply because it's not the first court to have stated that it has the right to determine the limits of European law, European competence. This has been a feature of Czech jurisprudence, and I think that's a can of worms that the Commission will not be stepping into. But long term, and it's the second level of negotiations, I think ultimately that the German Constitutional Court will have a success with this judgment. What do I mean by that? Now, we have to look at the motivations of the German Constitutional Court. This is it's a dangerous time to be doing these sort of things. It's a dangerous time to be saying, no, hang on, the competences of the European Union are extending beyond those that have been delegated to it by the member states, and the European Court of Justice is playing along in that ultra-virus act, is allowing Europe to expand beyond the parameters that the member states have set. It's a dangerous time to be doing it. So why is it doing it? Now, I think we have to look back over the whole row of German Constitutional Court judgments on Europe, especially since the Brunner judgment in 1994. So there's Brunner, there's Lisbon, there's the OMT, and there is the public sector purchasing programme, there is Vice, and all of them are ultimately saying the same thing. European law was not conceived of as a constitution for a self-nominating polity. There is no competence. There's a lot of law within the treaties that is certainly not constitutional law in character, but unfortunately through the doctrine of supremacy has taken on the character of law that cannot be tested in political process. And this is the primary point of the German constitutional. All of that undermines constitutionalism, the rule of law, which is dedicated to the preservation of political process and the preservation of democratic process. Economic policy is a core function of democratic process. And the democratic process we find most strongly at the national level. Certainly, democratic process is developing at the European level, but it's not full-blown. And certainly, in terms of a technocratic institution like the European Central Bank encroaching upon economic policy as a subsidiary act, as a side effect of its monetary policy, this is not something that is at all in any way subject to democratic process at the European level. In essence, this has been, as the court has gone on, this has been its primary problem, the German Constitutional Court's primary problem with the expansion of European law. Where is democratic process in this? The integration duty. The court is ready, and has been ready again and again and again, to accept the expansion in European competences where a democratic approval can be found, where democratic oversight can be found. So I think Weiss, and especially in terms of the questions that the court had asked of the German Constitutional Court had asked of the European Court of Justice, is another step. It was another effort from the German Constitutional Court to the European Court. Where can we find this democratic backup for the expansion in European competences? The Court of Justice didn't answer. The Court of Justice did not open the dialogue with the German Constitutional Court. It batted away the questions, the fundamental questions of whether this related to a competence. It batted away without answering. Hence, the German Constitutional Court biting, actually sending out a signal. No, enough is enough. We find both the Court of Justice and the central bank to be acting in an ultra-virus manner. The signal, and I think the signal, to whom is now the signal? The signal is not to the European Court of Justice. The signal is probably not to the European Central Bank. The signal is to politicians at national level and at European level. You need to reopen the political debate. You need to start thinking about reconfiguring Europe in a political manner. There is an original sin here in European monetary and economic union, is that split in the competences between monetary powers and economic powers, and too much being asked of a central bank that is required to intervene into areas that you would not normally see a central bank intervening without a political mandate. So what is the German court saying here? Is it saying we, the German Constitutional Court, are the masters of Europe? No, of course it's not saying that at all. It is saying, please, look to the failures, look to the lacunae in European law, find the political will, find the political dialogue to repair this danger, this hole, this damage in the rule of law, as well as in the democratic legitimation of Europe. I hope that's clear. Bit difficult, new technologies, but very nice talking to you.